The Supreme Court gets involved in a real sewage show, and it has a lot of environmentalists very happy. Hi, I'm Scott Ott, and this is Bill Whittle Now. And Bill, this particular case involves a sewage treatment or wastewater treatment facility in Maui, the Hawaiian island. And the case before the court was basically whether this treatment facility needed to have a federal permit under the Clean Water Act. And the reason for that was because under the Clean Water Act, if you're directly pumping any kind of pollutant into navigable waters, then you need this permit. The county, in this case, argued that they didn't need this permit because the effluent coming out of this treatment facility didn't go directly into navigable waters. In fact, it flowed through a series of pipes, and then it went through about a half a mile of groundwater. Essentially, it's in the earth and just passing through until it arrives at the ocean. Environmentalists said it was harming a reef off of Maui, and the county and the government was arguing that they shouldn't have to have a permit to do this because it was not a direct discharge into navigable waters. And Bill, the reason I bring this up is more than anything, not to say, do you think it was a good decision or not? I'll give you the breakdown on who voted for and against in a minute. But it just highlighted to me the difficulty of deregulation when you've got a situation where I think everybody would agree we don't want to destroy a reef. And I think most people would agree we don't want to dump wastewater into the ocean. But the question is, should the federal government be involved? Should there be a permit required from the federal government in this case? Just on the face of it, what are the first thoughts that come to your mind regarding a case like this?
Well, that's a great question in terms of first thoughts. The first thought that came to my mind is the swing your fist so long as you don't hit anybody else's nose argument, which is really the basis of everything I believe. You should be able to do whatever you want to with your own business, with your own life, so long as you don't interfere with other people's ability to do what they want to as well. And then you have to arbitrate it. If this sewage treatment facility is pumping water into the ocean that's harming marine life, then that sounds to me like you're hitting somebody else's nose. I don't know if I buy the argument about, well, it went somewhere else first. You could technically say, I suppose, by that argument, that as long as you passed it through some filter 400 feet off the property or let it trickle through a patch of grass, that doesn't necessarily mean that the contaminant is removed. So the reason I think that this is probably reasonable in terms of my first thought is, yeah, you don't have a right to go soil other people's campsites. And then as far as the federal permit goes, the thought that I had, and I don't even know how this would work, to be honest with you, but basically my thought was, how about instead of everybody having to get permission, how about if everybody just has permission and then offenders are investigated and then either informed, and if they don't comply, then they're fined if they are polluting the environment that we all share. But I remember when you said permit. I just hate that word. I hate it, and I don't. And I think that anything we could do to reverse the idea that we have to get permission from the government to do anything is something I'd be in favor of. So it's kind of a paradoxical argument. I think that the sewage treatment plant has an obligation to make sure that whatever they're dumping into the ocean is safe. And at the same time, I would hate the idea of permits for everything. I'd much rather just have people go about their business. And if it turns out they're causing harm, then you deal with it as a corrective issue rather than a permission issue.
Now, obviously, I think there would be a disagreement among the competing parties in this case as to whether they were causing harm or not. But I think it just really, in a way, illustrates how difficult this process is. And here's the breakdown, by the way, of the justices on the Supreme Court who, first of all, Stephen Breyer wrote the majority opinion for this. And with him were reliable liberals, Elena Kagan, Ruth Bader Ginsburg, and Sonia Sotomayor, but also John Roberts and Brett Kavanaugh. In the minority, we had Justice Clarence Thomas, we had Samuel Alito, as well as, I can't believe I'm leaving one name out, Alito, Thomas, who's the other? Oh, the new, Neil Gorsuch. Okay, so those three conservatives basically said what conservatives have complained about for years, which is the court is stepping in and legislating from the bench. They essentially, the court basically said, I'm going to read you the direct language of this. Now, a permit is required for discharge of pollutants that are direct, which the previous law said, or the functional equivalent of direct from the source. And Alito, who wrote the opinion for the dissent, or at least wrote the main one, and I think Gorsuch also wrote his own. But in any case, Alito wrote this opinion and said, what is functional? What is the functional equivalent of direct from the source? And who is to determine that? Now, the Supreme Court sent the decision back to a lower court to fine-tune this thing and clarify it. And there's actually something that conservatives will like a little later that I'll get into. But Bill, can you see the challenge of saying, well, you're legislating from the bench because you've said now you've got this functional equivalence standard. On the other hand, nobody wants to dump sewage into the ocean, so who decides?
Well, this to me is not legislating from the bench. Legislating from the bench would be for them to decide that a standard was needed. What they are trying to do is they're trying to interpret the standard that's already in place. I don't think that's legislating from the bench.
Well,
I think
that's exactly what Alito said they were not doing. He said you failed to interpret the standard because the standard was clear. The standard was direct from the source into the navigable waters. It didn't count underground flow when it left the source, and then a half a mile later it shows up in the Pacific Ocean.
Well, nevertheless, this still seems to me to be an appropriate role for the Supreme Court. They're not saying, hey, you need to put some kind of restrictions on this. They are doing what the ultimate court in the land is supposed to be doing, which is arbitrating on the language of legislation that they had nothing to do with passing. They are trying to come to grips with what the definition of functional equivalent is. And
well, no, they made up that term. That wasn't in the law. The original law just said it's pollutant that comes direct from the source. They've added this phrase, the functional equivalent of direct from the source. And that's what Alito was saying. Hey, wait a minute, you've opened that up to arbitrary and inconsistent interpretation, and you're not interpreting the law, you're actually creating a law there.
Well, direct from the source seems to me like traceable to the source.
And that's what the Ninth Circuit Court of Appeals actually said.
So if you can trace it to the source and the signal of the pollution, the signal is there and can be traced to the source, and that sounds pretty direct to me. If they go through a mile of groundwater, or if they go through a couple of millimeters of high quality filtering, either one of those is direct from the source, but the entire point of this is to stop this pollution from entering the ocean. Again, I just kind of think in this case, regardless of the details, which I clearly don't understand the details of the case, but it sounds to me like this is an appropriate role for the Supreme Court, that they didn't just decide to step in and do something as they did in the case of school integration and busing and so on back in the 70s. This is a case of, okay, well, we've got a piece of legislation, and we know what it's supposed to do. We know what its intent is. One side is claiming that no, I'm following the letter of the law, and the other side says technically no, and this sounds like what the court is supposed to be doing. It seems appropriate to me.
Now, if I remember it correctly from my research, the Ninth Circuit Court of Appeals used that phrase, fairly traceable to the source. But the Supreme Court actually brushed that back a little bit and said, look, that's going to be too vague because you could wind up in a situation where actually individual homeowners have to seek a federal permit. Or how do you decide how long it's appropriate for that traceable pollutant to get to the ocean? Let's say over a period of 100 years. Is that okay? If something that was a pollutant that was released in one place and slowly made its way out to the ocean, is that something that you should have to seek a permit for? And somebody could sue you if you didn't. So again, I think that the fascinating thing here is not so much how the case came down, but the great difficulty, because we're in the middle of something where the president is trying to unburden the country from some of these federal regulations. But even on something here that one side sees so clearly and the other side sees completely differently, you have a group of people in this country, I believe, Bill, who are saying, you know what, the important thing is the outcome. Outcome, clean water, and a reef that's not dying from pollutants. How we get there, not so important. And then other people are quibbling over permits.
Well, this is another example, I think, of why I hate permits and generally hate this kind of legislation in the first place, because the deeper you drill down into the wording, the easier it is to find a way around the intent of the legislation. Sometimes I think, and in fact, in most cases, I would argue the best thing to do is not go deeper into this and try and parse out the meaning of individual paragraphs. It's to step back and use common sense. For example, you said, well, would you need to get a permit for a pollution that didn't show up for 100 years? Well, common sense tells me that since I won't know about this for 100 years, this is a problem to deal with in 100 years. It's not something I have to speculate on right now.
But a scientist could project that and say, over the course of the next decade or 50 years or 100 years.
Well, again, in the next 50 years, 5 years, 1 year, 2 years, whatever the case may be, at the point where when that actually happens, when that pollutant gets into the water, then it's time to have that conversation. Otherwise, everything's just pure speculation, and there's no limits to that. You could put anything you want into that basket. Well, it might happen someday. It might be 100,000 years from now. No, if it's not polluting now, then it's not an issue now. If it gets to be an issue later, then it's an issue later. But common sense tells us to just kind of stand back and let's just look at what's being discussed here. What's being discussed is a regulation was put in place to protect the ocean from pollutants. So let's start there. Is this the kind of thing that is appropriate, or is this just another case of just overzealous government red tape? To me, this is exactly the kind of thing that the EPA should be doing, and only doing these kind of things. Is the environment being polluted? Is somebody else infringing upon the rights of other people by having one person pollute an environment that other people live in? That's the entire argument. In this case, that seems to be the case. So if it seems like that the legislation is justifiable from a constitutional point of view, and also from a just sort of a conservative philosophical basis, if that idea of that kind of legislation passes that bar, then the question is, why are we arguing about this? We know what the legislation was put in place for. The question isn't the wording of this. The question isn't direct to or from or whatever. The case is there pollution coming from this plant that is showing up in significant quantities in order to affect marine life? And if the answer is yes, then they need to change their procedures.
But the Supreme Court can't rule on what the people intended. They rule on, and in fact, constitutional textualists would say that if you're analyzing an act, you must analyze it in the words that exist in the act, not in what you think the intention of the lawmakers might have been. And if it says direct from the source into navigable waters, then you've got precise language there that doesn't allow you, if you're a constitutional textualist, to step back and go, well, they certainly must have meant that if it passes through a half a mile of the ground before it gets to the ocean, then that's included. Okay,
fair enough. That's a reasonable argument. And the of all the mysteries, of all of the, practically divine mysteries of the structure and the beauty of the Constitution, I think the one that continues to hold me most in awe is how simple it is and how hard they worked on to make all of these things very clear, very simple, and very, very difficult to get wrong. Now, when you're talking about a regulation, you're not talking about the Constitution anymore. So now on reflection, I suppose, since I've had a whole 3.5 minutes to think about it, I suppose now on reflection, what I would have done if I was the Supreme Court would have been to say that this regulation is unclear. I'd send it back to the regulatory agency, and I'd have them rewrite it.
So here's the obvious, and I didn't read the whole case. I just read coverage of it.
But hang on, I'm sorry. Let me just say this. It's like the argument about when they were trying to define pornography, right? I can't describe it, but I know it when I see it. To me, this is a pretty clear case of that. We know what the legislation was put in place for, and if they can prove that pollution from this plant is actually getting there, then we know the difference between a live horse and a dead one, so why don't we just stop flogging the latter? This is the kind of thing where where we run into danger by having so much reliance on regulations and precise wording. This isn't a constitutional issue. This is a regulatory issue. This reminds me of the case where the kind of thing you see in releases where it basically says something to the effect of, you shall not copy, reproduce, etch, mimeograph, paint. And it just lists every single possible way that you might be able to copy something. What all it should say is you should not be able to copy this. And they go into all of this minutia and all of these details and so on. And all it does is it doesn't make anything clearer. It makes it more opaque. And because of the legal system that we have or have evolved into, there's no longer a question of being able to say, why are we even having this discussion? It's clear what the intent of this law is. If you were able to reproduce this through means of neutrino spread, then it's not in the contract, but it's clearly copying it. So why are we having this discussion?
And yet courts are not set up to evaluate intentions, but rather the letter of the law. Let me get to why this is such a big deal, because you wonder, how could a sewage plant effluent case from Maui wind up all the way up at the U.S. Supreme Court? You don't have to read into the case to figure this out, though, because clearly the environmentalists who sued believe that requiring a permit under the Clean Water Act will stop or severely hinder that water from getting into the Pacific Ocean. And the people running the wastewater treatment plant believe that if they were required to seek a permit, either it would impose a great initial and ongoing burden, a great expense, or they couldn't get the permit at all, and they've got 4 million gallons of wastewater on a daily basis that they have to find something to do with. And so that's where the rubber meets the road when it comes to regulation, is the burden and expense of being able to fulfill that regulation. And at that point, if you're a business person, you're saying, well, what can I do? I mean, if I'm providing a service to the public here, in this case, it was the county with their wastewater treatment, but, this is a service that I provide. It can't be done unless that water goes somewhere.
So let's try and break it down again. If he was releasing mercury into a river or into the ocean directly, I don't think we'd be having a discussion about whether this is appropriate or not. It clearly is not. Same thing for if he was releasing radioactive gas. We wouldn't be having much of a discussion about that either. So if the question becomes, well, if he does need to seek a permit and that puts additional financial hardship on the plant in order to make the standards that the law was there to impose, then you have to ask yourself a couple questions. First of all, again, I don't know much about this. If it's a private company and they are, if it was a car manufacturer,
it's run by the county in this case.
Okay, well, let's say it was a private company, a car manufacturer. Let's say a guy built a defective toaster or something like that, and then they said, no, this doesn't comply with the regulations. You have to fix it. And they say, well, that's going to cost us a lot of money. They either pass that cost on to their customers or they go out of business. That's pretty much it. In this case, since it's being run by the county, and since it sounds like a utility rather than a product, then you have to start asking yourself the other end of the question, which is what is reasonable in terms of potential outcome. And what I mean by that is, let's just walk it through. Let's say that an environmentalist has determined that this amount of pollution is unacceptable and it's killing a reef. And let's say that the treatment plant says, no, it's not significant. And by the way, we can't do what you want us to do. And we've got this 4 million gallons of wastewater every day. Then you have to ask the question, I suppose in court, okay, well, what happens if he doesn't get the permit? What happens if we rule in favor of the environmentalist and this causes the plant to shut down? And then 4 million gallons of untreated wastewater go directly into the Pacific Ocean because there's nowhere else for it to go. Now we start getting down to the heart of the actual matter.
And the environmentalists would say no cost is too great. The taxpayer should be willing to bear the burden.
But this is the point. If it turns out that no cost is too great and they simply don't, then it's time to shut down the plant, because we can't do it. No cost is too great. Well, we don't have the money, so we can't do it. So you are now going to get 4 million gallons of untreated wastewater going directly into the Pacific Ocean. So why don't we get together and work out some kind of an arrangement here that is the minimally bad arrangement for both parties. And whether the environmentalist likes that or not, and I know they won't, because environmentalism at one time had a pure purpose. And I remember when the, just black smudges of jet exhaust and blue smoke out of every car, and the Great Lakes were poisoned, dead and all the rest of it. But there is a point where there has to be some kind of a trade-off. And there also comes a point when you run into the sheer functional economic realities of the situation, as we are dealing with the COVID-19 shutdown right now. So there comes a point when you really do have to say, well, I know you think it would be nice if there were no emissions from anything, but that's not going to happen. And I know you think it'd be nice if you didn't have to pay a dime and just simply could dump this into the ocean, but that's not going to happen either. So now the question is, what can we do that is the least bad outcome? And that doesn't seem to be what the court is addressing. And I don't blame them for not addressing this, because this is not a case. This is an entire philosophy. It's not even a political philosophy. It's an acceptance of reality. It's an acceptance of reality. We live in the real world. We live in a world where there are actual things that actually happen, no matter how much we may want things to be different. And for an environmentalist to say that there should be zero emissions from this plant of any kind that could even be potentially harmful, that's the position that environmentalists take. If you want to go to the other extreme and take the cartoon example of the capitalist robber baron, it's like, I don't give a damn about the environment. I want to make as much money as possible. Okay, so now you have your two poles, but reality lives between these two poles. Reality is almost always, not always, but almost always, it's on a spectrum. And fine-tuning the spectrum is what governance is about, and conservatism should be, I think, a desire to find that place in the spectrum that maximizes freedom and happiness. And with that said, there are those two things that have to be considered. Again, it's very similar to the COVID-19 argument. People talk about Dr. Fauci just as an example, and other scientists and medical doctors who are saying, well, we should be locked down for 2 years. And they said, that's ridiculous. But that's not their job. That's not the job of the epidemiologist to determine the economic outcome. His job is to say minimum casualties means locking down for 2 years. And then you've got somebody who's got a completely different argument. And then the job of the president is to decide where on this spectrum of shutting down for 2 years, reopening tomorrow, or reopening or not having shut down at all, where in that spectrum do we find the place that is the least worst outcome? And in the case of the shutdown, I think everybody feels more and more every day that we have now, the balance pan has shifted, and we need to start looking at the other alternative. But as far as the case goes, Scotty, certainly it doesn't seem to me like the Supreme Court is overreaching, and it just sounds like it's badly written regulations, and I'd like to get rid of them as many as possible, frankly.
Ladies and gentlemen, one of the things that I enjoy about this program and the people who support it, the members at BillWhittle.com, is that we're not given to facile talking points. We don't just say, well, what's the conservative line on this, and we'll spew that. But we actually try to think through these issues. We challenge ourselves. We bring up the arguments of the other side and deal with them in a legitimate fashion without caricaturing them or attributing evil motives to them, although we occasionally do that, but we have to deal with those arguments. And if you enjoy this kind of civil dialogue, a thing that I thought was once dead in this country, then perhaps you're the kind of person who would like to join our members in producing this program. That number of membership has been growing on a daily basis as more and more people have signed up to be part of this team, and we're grateful to them. If you'd like to do that right now, you can use the link in the description below and go to BillWhittle.com and click that Become a Member link. For Bill Whittle, I'm Scott Ott. Thanks for watching.